Stormy Daniels is suing to undo a non-disclosure deal she signed just before the 2016 election. Earlier this week, we spoke to her lawyer, who's accusing the president's legal team of, quote, thuggish behavior. As we're hearing, CBS is still vetting this and deciding whether or not to run the interview with the adult film performer. So joining me now is David Schwartz. He's the attorney and friend of Michael Cohen. Now, Cohen's the one who drafted the non-disclosure deal that's now being challenged. David, great to have you with us tonight.
Hi, Shannon.
All right, let's start with Mr. Avenatti was on with us Tuesday night. I know you guys have sparred in and out of court, so let's play a little bit of what he had to say. We'll get your reaction.
She didn't get the binding release in the agreement. Mr. Cohen could not bind Mr. Trump under the agreement. This is going to be thrown out. There was no agreement.
Right. You know, I'm thinking back to my years of law school and the bar exam and practice and all that kind of thing. I mean, people who aren't parties to the agreements can benefit from them, correct?
It's called the third-party beneficiary rule. Of course, you know, these are fictional arguments that Mr. Avenatti is making. Clearly, the agreement was between EC LLC and you know, the person was EC, the entity was EC LLC. So clearly there was an agreement, there was consideration, there was money passed, and she received the $130,000. It's an agreement, and the courts tend to side with creating an agreement, and they look at the intent of the parties. So I think it's pretty clear.
Okay, so I went through a lot of this agreement with him the other night. Of course, you know, their argument is because President Trump did not sign it, that they're not bound by it. Okay, so let's walk through some of this. In paragraph 8.6 of this the non-disclosure agreement, it says, this agreement, when signed by all parties, is a valid and binding agreement enforceable in accordance with its terms. Then at the end of the contract, it says this, in witness whereof, by their signatures below, the parties each have approved and executed this agreement. Now, there are 3 lines there for signatures. One of them would have been for the president. He did not sign it. So how do you fight that argument in court?
Very easily, because in the beginning of the agreement, you have an and or. So it was either EC LLC or DD. So
people know that's the entity that Michael Cohen created to handle this deal, is that EC LLC.
Right. That's the entity. It's a separate entity. So it's and or. Now, Mr. Avenatti was trying to make a whole to-do of the and or, and it was in the conjunctive, and the parties should have been reversed. He's finding every technical argument possible. None of them are going to fly. And then he starts mentioning California law, as if there's something mysterious about California law, that they define the and or the or differently than we do in New York. Well, I looked at the California law, and the California law is very clear that it's either or. It's defined as either or. So either EC LLC could have entered into, DD could have entered into it, or both of them could have entered into it. And you ask why? Why was there a line at the end? Because Michael Cohen wanted to have the opportunity, if he wanted to show it to Donald Trump. If he wanted to show the agreement to him, he had the opportunity to do so, which also answers the question, he didn't show it to him.
Yeah, that's my question. When did the president know about this? He
did not know about it at the time. He found out about it much later on, when we all found out about it.
Okay, so who first violated this non-disclosure agreement? Because you know her team says it was Michael Cohen, not them.
No, absolutely not. So what happened was Michael Cohen, there was a subpoena from the Federal Election Commission, which Michael Cohen had to answer, all right? So he had to answer that complaint. So clearly in the agreement, when you answer, that's provided for in the agreement, he had to answer for it. There were leaks from the federal, you know, lo and behold.
Somewhere.
There were leaks from the Federal Election Commission. However, the agreement clearly, even in a situation like that, Stormy is still bound by the terms of the agreement. It doesn't give her the right to start to say, oh, Michael Cohen violated the agreement, so now I could freely speak. Well, that's not the way the agreement works.
Well, the agreement was filled with language about breaches to the tune of $1 million each. I know that the documents you have in federal court say you think that she's gone at least into $20 million into this. You know she doesn't have $20 million, so what's the point?
Oh, because the whole point is Mr. Avenatti has basically told her that she's going to make a fortune off this case. She's going to make millions and millions and millions of dollars. Well, the problem is Michael Cohen will not rest until he collects every single penny of that money. So although she doesn't have the money now, there's certainly future earnings, and there's a disgorgement clause in the contract as well.
Okay,
so he will
let me ask you really
disgorge every
quickly.
single penny.
Okay, let me ask you really quickly because we got to go. What's the next court date on this? Do you have any kind of proceeding for discovery or anything else in the federal court?
Yeah, just to make it very clear, I am Michael Cohen's attorney in his defamation case against BuzzFeed. So he has other attorneys handling
the
this
rest of
case.
this. Okay.
So I'm not sure when the next court date is, but I am an authorized spokesman for Michael Cohen as to all these cases.
All right, we've now heard from both sides. David Schwartz, great to have you with us tonight. Thank you very much.
Thank you, Shannon.
All right, you might have